Okay, good afternoon, and welcome to everybody. And we're really happy that you came to join our circle on judicial conflict resolution. Just to remind us, this is the first more substantial meeting for this semester. And in each meeting, we will have one disciplinary or interdisciplinary aspect of the research. We have the next circle dealing with Jewish law and the role of the Dayan. We have one panel dealing with ethics. We have a panel dealing with judicial behavior. And we will have more, and we had before. And the idea is really to create a broad perspective of this new phenomena of the vanishing trial, the role of judges within it, and the relation to the phenomena to conflict resolution and to possibilities of a different kind of justice. So this is the overall goal. And in this meeting, we are going to deal with the civil procedure aspect of this phenomena. The phenomena of settlement, the phenomena of the vanishing trial. And we have here a very distinguished guest. Our guest today is Dr. Rabeea Assy from Haifa University. He's an expert in civil procedure and in evidence law. And as a respondent, we'll have Dr. Hanan Mendel from Ono College, and he will speak about, he's also an expert in civil procedure and digital justice, and he will speak about some kind of Israeli aspects of this debate. So we will have the UK aspects, the more UK perspective of the conflict. We will try to have some comparative elements related to Israel, maybe a little to Italy, though it's a different system. And I think that according to our tradition, first before starting, we'd like to go around the table to see the people that are around that came in. So I'm Michal Alberstein. I'm the PI, the primary investigator in this project of judicial conflict resolution. And I really enjoyed the last month in leading the team that work on this project in various aspects and discipline. And I'm from the law faculty here at Bar-Ilan. Rabeea already introduced you.
And Hanan was also introduced.
I'm Omer Shapira from Ono Academic College, law faculty, a colleague of Hanan. I'm dealing mainly with the mediation ethics, and here with the ethical aspects maybe of judicial conflict resolution.
My name is Merav. I'm lawyer and mediator, and I'm intending to be a student for PhD.
My name is Gilad. I'm also a lawyer mediator, and I'm already a doctoral student in the conflict resolution program here in Bar-Ilan.
Dr. Karen Perlman. I teach in a strict school of law of the College of Management Academic Studies and head of the Non-Adversarial and Therapeutic Justice Center there.
Dr. Menachem Mario Klein. I'm a judge in Tel Aviv Trial Court, and also I'm teaching here in Bar-Ilan University.
Valerie Munari from Kenya, formerly a master's student at the Haifa University, and now research assistant with Autonomy the new project.
I'm Dr. Sivan Shomragon, and I'm a lecturer here in the law school, and my main areas of research are international economic law disputes.
And Dr. Borat Mizon, and I'm here at postdoctoral at Bar-Ilan University.
Dr. Michal Roman, qualitative research
advisor
of the project.
Norit Zimmerman, the director of the research, and I have Diana Richards, who is our London-based coordinator for England. But she's in a noisy place, so she's not able to speak. Hi, Diana.
Hi, I'm Ronit Cohen. I manage the ERC clinic here in Bar-Ilan with Michal. I'm a lawyer and mediator, and I'm student in the research.
Hi, I'm Tony Raziel from the State Controller Office in Jerusalem. I'm a lawyer also. I'm a candidate PhD program here and supervised by Professor Robinson.
Okay, thank you. So we'll now turn to our speaker, Dr. Rabeea Assy. And I think part of what we'll hear is really the civil procedure aspect of the phenomena of settlement, or the relationship between civil procedure and the pursuit of settlement and conflict resolution, together with questions of incentives, of questions of cost for parties. So he will tell us the rest, but please.
Thank you very much, Michal. Thank you everybody for coming. I'm very happy to be here in Bar-Ilan. It's really a pleasure and an honor. I would like to start with a quick note on the nature of the English system. As you probably you might know, England has a long-standing adversarial tradition, at least up to the Wolf reform, to which I will return later on. And just to start with the basics, by adversarial process we mean that the judge is a system in which the judge is largely passive, a referee, an umpire, and the parties bear the primary responsibility for collecting the evidence, presenting argument before the court. Adversarial systems are normally contrasted with inquisitorial systems, and this is the idea of judges errants, roaming the land in pursuit of justice, judges who commence legal proceedings, collect evidence, etc. Now, it's very important to emphasize that it's one of the most persistent misconceptions in the study of civil procedure to assume that in their pure forms, these models represent actual legal systems. In fact, if we examine, the misconception goes on by dividing the world into two families, so the common law adversarial systems and civil law inquisitorial systems, which is simply false, because European systems are not inquisitorial, at least not in the sense of having judges roaming the land in pursuit of justice. So the European judges do not commence legal proceedings, don't search for evidence. So inquisitorial systems do not really exist. The systems around the globe, civil procedure, the civil justice systems around the world are actually different points along one spectrum of being more adversarial or less adversarial. So even the European systems are adversarial to a lesser degree. Obviously, the judges have a much more active role in European systems, but still they are not inquisitorial in the sense that they don't really go and look for evidence. So the English system has been an adversarial system. And I would like to obviously there are multiple definitions. There are various definitions of what an adversarial system is. So here is one of them given by Stephen Lanzmann. And there are three main elements of an adversarial system. First two actually are related: judicial passivity and party autonomy. And the third one is a formal structure, complex rules of procedure and evidence. I'll talk about each of them in a moment. But my attempt here is to try to analyze the changes in the English system along these lines, to see how the English system developed over the years along these 3 points. Okay, so as I said, the English system, at least up to the Wolf reform, used to be strongly adversarial in the sense that it afforded litigants a high degree of control over the proceedings. And when we talk about the idea that justification is normally a liberal justification based on autonomy, litigants are the authors of their lives, and it follows from this proposition that they have the right to control the proceedings and to pursue their cases by using also them not only defining the goods that they choose, but also defining the means by which to pursue the good. So the justification of the adversarial system used to be a liberal. When we talk about party autonomy, we have to distinguish between two senses of the principle. One sense has to do with the initial decision whether to start legal proceedings, whether to file a suit, and the ultimate decision whether to terminate the suit. And all legal systems actually respect this aspect of the principle of party autonomy, because all systems around the globe, they all give litigants the exclusive power to start and to finish and to end legal proceedings, and hence we don't have. That's why we don't have inquisitorial systems. So in that sense, all the systems, whether European or whether common law or civil law, they all provide litigants, afford litigants complete or exclusive power over the initial question whether to start a legal process or to commence. The second aspect, which is actually more controversial, is the degree of control given by the system to the parties, and it's here actually where the legal systems around the globe diverge. So common law systems tend to afford litigants with a higher degree of control, whereas civil law systems provide litigants with lesser degree of control over the process. And England used to be a highly adversarial system in which parties had a very high degree of power over the system, over the legal process. So they decided what to do with the case. The judge had a very minimal role. And that brought this legal system, the English legal system, into disrepute. When you give private and self-interested parties the power to manage a public service, they would manage it according to their own self-interest and not in line with any public policy of efficiency. And that's why the English system turned to become really a monster in terms of costs and inefficiency. Against this background, the Wolf reform tried to bring some a fresh spirit into the English system, and the main changes actually touched upon each of these three elements: party autonomy, judicial passivity, and the simplicity or the complexity of the legal process. So let me move to the to the new procedural code, which was enacted in 1998 following the Wolf reform. This procedural code starts with an overriding objective, a declaration of a statement of purpose. What is the function of the legal process? And we can see here that the overriding objective instructs judges in civil proceedings to dispose of the case justly and at a proportionate cost. And that means, if you look at all the different subsections, we are talking here about efficiency, about saving costs, about justice, or it is an efficiency-based definition of justice that seeks to cut the costs as much as possible. And this comes, as again, as I said, this comes against the background of expensive and very inefficient legal system. Now, the CPR, the Civil Procedure Rules, also instruct judges, and that is really a major departure from the classical adversarial system, instructs judges to actively promote, actively manage cases, actively promote the overriding objectives. And what does that mean? What is meant by actively promoting case management? It means a lot of things. You can look at into CPR 1.4, but the point here which I want to make, which is related to this forum, is that the CPR, the Civil Procedure Rule, actually they use settlements and ADR options as an accessory, as a way in which to reduce inefficiency. So here is an opportunity now. Because of the inefficiency of the system, there is now an opportunity, a golden opportunity, to try to bring parties to talk together. And the judge has an active duty to, as you can see, to encourage parties to cooperate with each other, to encourage them to use alternative dispute resolutions, etc., etc. So from an efficiency-based definition of justice, the CPR moves on to encourage judges to promote settlements, to promote ADR. But again, we have to bear in mind that the CPR do so based or against a background of inefficient proceedings, not necessarily out of some awareness of the independent merits of ADR. And that's something which is very important to bear in mind, because we need to ask ourselves whether it's socially valuable to have parties go to ADR and negotiate settlements when they know that they don't really have a viable option of litigating their case and receiving a timely and not very costly judgment. So we can see here that there's actually a development or a departure from the classical adversarial system by providing, furnishing judges with extensive powers of case management. Now, if we go back to the definition of an adversarial process, so the adversarial process focuses not on, or requires not only party autonomy and judicial passivity, but also a formal structure and rules of evidence and procedure. What is meant by that? Now, there's a unique feature. One of the things that distinguish common law proceedings or English proceedings from civil law proceedings is that unlike civil law proceedings, in common law there is a clear distinction between the trial stage and the pre-trial stage. The trial stage is also structured in a very formal way. So you have the claimant starting first, and then the defendant. Examination of witnesses is built in a way where, so you have examination in chief, cross-examination, and then re-examination. So it's a structure. Everyone has a specific role in it. Whereas civil law proceedings, they develop on an episodical fashion. So the judge would receive evidence all the time from all the parties without any structured. There's no trial in civil law countries. So there are several hearings in which the judge would receive evidence all the time. But in an adversarial system, there is an order and there is clear distinction between the trial and the pre-trial stages. And also, there are strict rules of admissibility, of evidence admissibility. In civil law countries, there is a tradition of free proof, more or less, right? So parties can produce evidence as they like, whereas in common law systems, in adversarial systems, they are not allowed to do so. There are rules of admissibility. These are characteristics of the adversarial system, and they used to characterize the English system, and they still do, subject to the following. The Wolf Reform tried to enhance access to justice by an attempt to simplify the process. So the idea behind the Wolf Reform was to try to unify the process. Instead of having different forms of actions or different forms of proceedings or different ways to start a process, now we have one way. It's claim form. You file a claim form, and that's how you start your case. And then the Wolf Reform tried also to modernize the language, and instead of using Latin, say ex parte or writ, so now they use claim form and without notice or with notice proceedings. So the terminology changed, and the Wolf Reform tried to make the law accessible, or the procedure accessible, by making the language more accessible. And it did so with some success. But the main thing which happened in the last, say, 15 years was the change in evidence law. So when the hearsay rule had its deep roots in common law and the English tradition, or in the English adversarial tradition, it's now actually in England where the rule against hearsay has been disposed of in civil cases. Now, in civil cases, parties can admit hearsay, and that will not be screened out by any rule of admissibility. This is thanks to the EU influence, because, as I said, civil law countries subscribe to the free proof tradition. So one of the impacts of the EU was actually to bring England to dispose of the hearsay rule. And that's a big change, because now parties, as I said, can admit any evidence they like. But still, we should not exaggerate the effect of this change, because after all, judges will have to weigh the evidence, and obviously that if a hearsay, an item of evidence is admitted, that does not mean that it will weigh significantly in the balance. So one final point on this: in England, there is still a clear division between the trial and the pre-trial stages. And unlike in Israel you have the same judge handling the case from start to end. In England, the pre-trial stage, the procedural stage, is actually dealt with by a procedural judge, and then the trial itself is dealt by a different judge. So there's a separation between the two stages, and in that sense, the system is still largely adversarial. Now I'd like to move to the issue of costs, and that is a big issue in England. In England, costs follow the event. What does that mean? Cost liability depends on the result, on the outcome. The idea is that the party who wins the case is entitled to all of its actual and real costs. So the loser will have to pay the winner's cost. Subject obviously to limitations of reasonableness and proportionality. The philosophy or the principled justification for this rule is quite obvious. The idea is that if you go to court, you should not incur any financial loss. The English rule of cost shifting, of cost follow the event, seeks to make the winner whole, to compensate him or her for her financial loss, right? So in a way, it makes access to justice free. So if you want to defend your legal right, you shouldn't pay a price. You shouldn't pay any tax for that. Unlike the American system, in which each party has to bear its own cost irrespective of the outcome. So this is a unique feature of the English system, which has its own justification. And the idea is that by having this rule, by shifting the cost on to the losing party, the English system tries to deter frivolous cases. It provides an incentive or disincentive to file frivolous cases, and it also provides an incentive to file meritorious cases. Because if you have a strong claim, you should not be deterred by the cost element, because you can then claim them back when your rights are vindicated. In theory, even impecunious litigants should benefit from this rule, because even if you don't have the money to hire a lawyer, you can still do so knowing that when your rights are vindicated, you'll get the money back. But as you all know, there's a difference, or there's normally a gap between theory and practice, and things turn out to be to play in a different way. So there are lots of gains by having a cost-shifting rule, but there are also very severe deficiencies in the system, and I want to talk about them very briefly. I want to introduce a principled objection to the cost-shifting rule which is followed in England. If you think of it, the cost-shifting rule treats the losing party as a wrongdoer, as a tortfeasor. If you lose, that means that you did something wrong, that the act of litigation was a wrongdoing which entitles the opponent with compensation. Restoring the original position. This is a flawed reasoning, because it actually presupposes a very thin conception of access to justice. It only means a permission to go to court and litigate your case, but that does not mean that if you lose your case, you'll be immune from any sanction, from any consequences. A thicker perception of the right of access to justice could mean that you have a right to have your claim investigated, and you will be immune from costs because you have a right to ask the court to investigate your claim. At least when we have a genuine and honest dispute, and people can reasonably disagree about the facts and disagree about the law. In these cases, there is no justification to actually impose the cost on either party, because each of them has a right to access to court, has a right to have the dispute investigated. So that is an objection on the principle level. But there are also practical difficulties with the cost-shifting rule. And these are actually the problem, of course, is a result of several factors. First, we have the cost-shifting rule, and secondly, in England there's a rule of law against champerty. Are you familiar with this concept? It's a very awkward word. It means that champerty. It means that a lawyer cannot charge fees based as a percentage from the outcome, which is something which we do in Israel, which is very acceptable in Israel. Exactly. So in Israel we have it in criminal law, but not in civil proceedings. In England, the rule applies both in civil and in criminal cases, and that's an interesting thing because now lawyers charge by the hour, and when you charge by the hour, you have every incentive to protract litigation, right? And not only that, when you combine the cost-shifting rule with charging by the hour, you build up a system which actually is completely unpredictable. As a litigant, you have no way to control your own costs, let alone your opponent's costs. So costs are not predictable, and the stakes are very high. When the stakes are very high, when costs are a big issue, then the English system will not only deter frivolous cases, but it will also deter many meritorious cases, because many litigants are risk averse, especially poor litigants, especially those who don't have the financial means. They will not file a suit because they will not be able to run the risk of having to pay the other side's cost. There might also be a race to the bottom. We all know actually that the more you spend on litigation, the more likely you are to win. So both sides have every good reason to invest as much as possible in the process so as to win, because the winner takes it all. When you win, you will receive everything back. And if that is the case, this gives an advantage, obviously, to the pocket. If you are litigating against the corporation will try to outpay you. It will enhance the risk, raise the cost, so much so that you will have to settle. You will have to quit litigation because you will no longer be able to bear the risk. So there are lots of complexities that we need to actually consider when we assess the English system of course and its impact on the likelihood to settlement. Now there's a lot of writing, there are a lot of mathematical models which try to examine the impact of the cost-shifting rule on the tendency to settle, but it's very difficult to go through them here, so I'll simply refer you to Bibchuk's work on the subject. And here I come to what is called as, what is known in England as Part 36 offers. In England, there are various ways various techniques that parties could use in order to protect themselves from this monster, from the cost monster. One technique is Part 36 offer, and it refers to Rule 36 or Part 36 of the CPR, Perek 36. And the idea is this: it's very simple. If you are a litigant in England, you can make an offer of settlement. Suppose that I sued Hanan for £100,000. He can make me an offer. He can tell the court, well, I am ready to settle the case for £50,000. If I accept his offer, well, obviously the case is settled and everybody's happy. If I decline the offer, then the cost liability will depend on what happens later. If I fail to achieve a better result, if I get a judgment on any sum which is lower than his offer, than £50,000, then I will have to pay his costs all the way down to final judgment. Now this mechanism is available not only to defendants but also to claimants. I can make him an offer and invite him to settle his case on, say, £70,000. And if he declines the offer and fails to achieve a better result, then he will not only have to pay me my costs, but he will also have to pay me very high interest, about 10% on the cost, and also 10% on the value of the claim or part of it, depending on what the judge decides. So the system here provides incentives to be realistic and to settle. Now, when you are a litigant who doesn't have a lot of money, and if you are suing Deep Pocket, Then, if the deep pocket makes an offer, you'll have to take it very seriously, knowing that if you fail to achieve a better result, then you have to pay their cost, which is a lot of money. And that system, which seeks to promote settlements, can provide further source of pressure on litigants. Okay? So this is more or less the idea. And, a similar mechanism also exists in the US through Rule 68 of the Federal Rules of Civil Procedure. But in the US, only defendants can make such offers. Claimants don't have this mechanism. As I said, in England, it's available both ways. Do you still have time to talk about representation, or? A little bit. Okay, so that's one item, one issue which has impact on both access to justice and also settlements. I'll also talk about representation, which is a topic which is very important nowadays in England. In common law systems, and especially in England and in the US, self-representation is considered a fundamental right. It's a constitutional right. Nobody can impose legal representation on you. You have the right to litigate in person. In fact, self-representation is taken as self-evident, as a natural good, as something that, as a natural expression of the right of access to justice. Rights are personal. If you have a right to litigate, then you have, naturally, the common lawyer would tell you, naturally you have a right to exercise the right in person. However, while self-representation is self-evident in the common law world, it's actually far from being self-evident in the rest of the world. In civil law countries, in most civil law countries, self-representation is actually prohibited. You've got to have a lawyer as a condition for filing a suit or defending a suit. And most of these systems require representation as a compulsory requirement. This is counterintuitive. This is a paradox. Why is it a paradox? Because if you think of these systems, if we say that civil law systems are systems in which judges are more active and the parties have a more reduced responsibility, then you would have thought that it's actually these systems that should have provided self-representation, because self-represented litigants would have fared much better in these systems as opposed to the adversarial systems where the judges are passive and the primary responsibility is actually that of the parties. But as it turns out, self-representation is afforded in the legal systems where self-represented litigants will fare very badly, whereas it's prohibited where they could have fared much better. Why is that? And whether on which system is more justifiable in its approach to self-representation is a big question which I will not address here. If you'd like to know more about it, so read my book. I'm not promoting myself, but okay. So self-representation is a fundamental right in England, as in many common law countries. And the numbers of self-represented litigants are ever on the rise in England and in the US and in many other common law countries. Why is that? Because legal aid is being cut dramatically, especially in 2013. The British government cut legal aid substantially in a way which actually made it largely unavailable to most people. And the irony is this. These governments deny litigants or provide litigants, deny them legal aid, and then they tell them, well, it's your autonomy. It's your free choice. You have every right to choose your goods and to pursue them by whatever means you like. So we cannot deny you this right. That's what you have self-representation. So self-representation is being justified in liberal terms, where in a way that tries to blind us to the injustice that is being inflicted upon self-represented litigants. One of the solutions that were offered in England to try to ameliorate or improve the injustice that is, or try to redress the imbalance between represented and unrepresented litigants was through what is called Mackenzie Friends. Mackenzie Friends are lay assistants. In England, you can, if you don't have money to pay a lawyer, you can either bring a friend or buy a friend. Pay money to somebody, a layperson, who would assist you conduct the litigation. The general view about Mackenzie Friends is very positive. They treat them as having a positive contribution to the civil justice system. But bear in mind that lay assistants cannot address the court. They don't have rights of audience, so they cannot litigate on behalf of the litigant. What they can do is only to help with the paperwork, take notes during the hearings, and whisper silently and try to give tips to the litigant. That could help a little bit. It could help especially in specific proceedings, say in family proceedings, in labor proceedings, where the law and the facts are more or less defined. It's not a complex area. It could help a little bit, but it obviously cannot provide. It does not provide a general solution. The need for a solution is very acute given vast empirical evidence which shows the obvious, that self-represented litigants fare much worse than represented litigants. So if you don't have a lawyer, you are much less likely to win the case, even if you have a very good case. So you are much less likely to win the case. I want to finish this presentation by presenting the findings of a study which was conducted by my colleagues at Haifa, Ghazal, Perry, and others, which examined the effect of legal representation and self-representation on settlements, on ADR sessions. And the finding was very interesting. They found that legal representation actually improves or increases the chances for a settlement. But it increases the chances for low-value settlements. So if you are represented by a lawyer, you are more likely to settle the case, but then you would settle it on a lesser value. If you are self-represented, you are less likely, you would be less likely to settle, but when you do, it's on a substantially higher amount. That's one interesting finding. It could be explained, by the way, agency problem. It's possible to explain it. But one more finding, which I think is very important to mention here, speaking of settlements of ADR, is that the value of the amount of money that you would get from ADR is less than what you would get in full proceedings. And that is also interesting, right? So in a way, ADR or entering an ADR session in the court, the labor tribunal which was examined there, entering ADR session would enable you probably to settle, especially if you are legally represented, but then you would get less than if you were self-represented, and you would get less than if you pursued the case till a final judgment. This could be explained as well. There are various explanations, but I will leave it if you'd like to the QA session. Thank you very much for your patience and for listening. So,
because it gave me the opportunity, in order to prepare myself to your presentation, it gave me the opportunity to read again your book, because I read it at the time, and I enjoyed it very much. And I would like to help the audience by making my response into 3 parts, going backwards to what Rabeea talked about. Meaning, I will talk first about the self-representation, and then I will go on to cost, and then I'll go on to the overall picture as it started. And if we'll talk about self-representation, the things that happen at the UK and the United States and Israel are the same, but in a more extreme way. Meaning, the budget cut that was made to the system of legal aid in Israel, which was already very low in the civil procedures, in the civil matters, was cut even more dramatically than in the United States. it's interesting to state that when the Justice Ministry had to defend the cuts that happened at the legal aid system, they had two explanations. One was the regular explanation about the autonomy of a person, and not only autonomy, but talking about the fact that in Israel more and more people are more educated, and so they can represent themselves, which is, I think, rubbish. and the second one is even more interesting. They use the excuse of the new rise of the legal clinic. Meaning they said everybody who wants can go to a legal clinic in the universities and then get the aid that he needs. And that's a new excuse. I didn't hear it in the United States or in England, but in Israel it was done. Basically, I think that the position in Israel is even more problematic. We don't have Mackenzie friends. And everybody here at the table knows why we don't have Mackenzie friends. There is one big answer: the bar. In Israel, the lawyer's bar has much more control on what is going on at the justice system at all, meaning not only at the bar's ethics, but also what is going on about regulation and financing and so. And the bar doesn't want that this kind of mechanism of half self-representation will be done in Israel. And you have to remember that in fact we are sentencing the litigants in Israel to a vicious choice. Whether he will have to represent himself and not be aware of the many problematic and formalistics that we have in the litigation in Israel, or that he will use a lawyer which will hire the cost of the procedure and will also cause another negative implication on the proceeding. You don't have a middle choice. And though I can say that some of the things that happen in Israel, Carney can tell about this kind of collaborative lawyering that happen, and the phenomena of more and more lawyers that study and practice mediation can help to soften this one, but it's still, I think, it's on the edges. It's not on the mainstream. Most of the lawyers that give advice in civil cases do not use collaborative lawyering and do not use mediation in their practice. Usually, they divide themselves to be somebody that has two faces. One is the lawyer, the adversarial lawyer. Another one is doing a mediation work on the side directly with the parties. Usually, the combination of these two practices is not happening, and that's a big problem, again, which is worse than what is going on in England and in United States. That's about self-representation. Now I'll go to costs. And, well, I have to go to what Rabeea said at the start. We know there is no pure system of adversarial model or inquisitorial model. Israel is a very good example. Though we started as a more close to the adversarial system because of the impact of the mandatory government here, Israel is moving more and more to a kind of hybrid system. And like John Langbein once stated, we have a phenomena of transplanting parts of the procedures from various systems, and Israel is going on the same thing, the same transplant that essentially we are trying to add more and more inquisitorial aspects into our system. And the costs is a good example. Meaning we started like the old rule, the old English rule. Meaning that the side who wins, the cost shifting rule, meaning that the side who wins will get the costs. Unlike the American model, which is a system that everybody has to bear his own costs. And what happened there is that in England and in most of the other places, this rule was a little bit more changed, like Rabeea described with the rule of 36. But in Israel, there is no, there is a rule of 36, meaning that the defendant can give the court amount of money, and the court will take it into account about the costs. But the bidding game that Rabeea described, meaning the place where everybody can make a proposal and exchange the proposal and respond to it, doesn't happen in Israel. We don't have it. We were stuck at the old English rule, and we still didn't change it. Even at the proposed reform, the long-awaiting proposed reform of the civil procedure, there is nothing about this rule, meaning it will stay at the same. I have to say that I said that we have the English rule of the cost shifting. It's not written, meaning the courts interpreted the rules like this, where there is no something written at the rules that say that everybody that the winner should do it. That was produced by the Supreme Court decision, like by Bialik 10 and Katz and others. And what happened in the costs is that in order to make the system more inquisitorial and to give the judge more control, side costs rules were added. Meaning we have a lot of rules at the civil procedure regulation, at the Taxada, which give the judge a right to determine costs if the sides do not do something right. For instance, we have a rule that says that if the sides are causing the meeting to be delayed, he can impose costs. And there is a rule that says that if a side is not coming to a pre-trial meeting, costs. And there is the new rule about the mahut, the mandatory mediation, which says something very weird. It says that if a side doesn't come, he should pay the costs of the mahut, that didn't happen, of the mahut meeting, and that the judge will take it into account when the decision about the cost will be. Because there is no mechanism at the regulation about costs in Israel, that and many other sub-cost rules are not relevant. As you know, I'm saying something new. In Israel, there is no, in Israel and also in England, there is no realistic costs. Meaning the decision about the costs is not based on evidence about the real costs of the procedure, but on the judge's discretion, and also, if we talk about the bar power, about what is the minimal fee that the bar is proposing to this kind, which is normally not used even today, but still it has an impact on setting the costs, at least for the lawyers costs. The system was supposed to be reformed at the new reform, but surprisingly, like Alon Clement wrote about it, in the reform there was nothing about changing the cost law. It didn't handle it at all. So we are still in a stage where basically we are in the old English rule. There's starting to be there are a lot of bandages that try to fix the issue and it doesn't work. And we didn't have even the English advance about the cost mechanism. I would like to add that the Rule 36 is showing us the importance of costs to the settlement issue. Meaning, if we will talk about the contact theory, for instance, it gives the parties opportunity to exchange views about the conflict. The way that they have to propose the offers is giving them something like, I said, a bidding game, but interaction between them that helps them in the way to make a settlement. As I said, it's not an existence in Israel. Another aspect, of course, which is important for settlements, is of course the impact of the lawyers that Rabeea also turns about. Meaning, a lawyer will have an incentive to hire, in most cases, not in like in the Ghazal and Perry article, not in lower cases, which usually lawyers see as burden, but in regular cases, where the lawyers see the money, it will give them an incentive to give more and more costs in the Israeli model, and therefore the cost is giving the parties each time and each minute in the process another opportunity not to run, because when you invest so much expenses, your incentive to settle is going down very much. So that's about the cost. I have something more to add. There is something interesting when in the 90s the Taxada was rewritten. An old rule about admissions was added to the start of the discovery stage at the pre-trial, and it says that if a party wants to admit the facts, or if a party wants the other side to admit on the facts on a document, he can do so. There is a mechanism, a pre-trial mechanism, in order to not broaden the conflict and to be less burden on the court. There is a mechanism that helps the sides to try to minimize the conflict by the admissions. And the only punishment, the only thing that is written on the admissions, unlike other kinds of discovery, of pre-trial discovery, which has a very strong punishment, deleting the case itself, or deleting parts of the court documents. In the admission period, there is no this kind of punishment. The only punishment is costs, but the cost there is not relating to the final cost of the procedure, but it's relating only to the cost that the sides have in order to prove the document or the fact that didn't come. Since we don't have a realistic cost regime, that's nonsense. Usually, if you talk about the use of 102, 103, 104 at the Taxada, nobody uses them, because the punishment is based on costs which are not relevant at all. Nobody, I think Judge Klein can be can give a better level. I've never heard about a judge that gave this kind of punishment on the admission stage. It is not used. You did? Yes? Once. You did a lot? No.
But how did you do it? You examined real costs, or
no,
just globally?
And usually when we talk to lawyers, they don't, though they learned civil procedure and they have the tests, the exams, the bar exams, they don't know about this kind of mechanism. Don't even know about it. I mean, there is a hodayot, and usually what they say, why it's called hodaya and not hoda'ah? Because it's called on the hodayot. So then why it's called hodaya? Nobody knows about it, nobody uses, and that's just the final thing about costs. What I want to finally say, that costs and the stage of representation are two good examples of the things that we have in the civil procedure that directly affect the settlement success. And there are a lot of stages in the civil procedure, not only at the obvious stages, meaning when the sides are being sent by the judge to go outside and settle, or mahut, or even other obvious stages. A lot of very delicate stages in civil procedure that affect the parties' ability to settle, and that's a thing I'm currently working about. I'm working about it. We will present in another session. Not here. Thank you.
Thank you. Maybe I will say a few words just to respond. Regimes of civil procedure and the way in which we perceive its effect on the parties are very important to understand the settlement realistic map. I think that in a sense, when we are talking about the UK, about Israel, about Italy, we have to understand the reality of conflicts, because what we see in the court is actually the people that get there considering all these conditions. But one thing that struck me when I spoke with Rabeea before the talk is the more ideological or philosophical perception of the justice system. Because you described the Lord Wolfe reform as responding to a system that was about justice on the merits. This was a long time, like a century long system that responded to a very procedural judging that was kind of tending to look into very particular problems in the process and dismissing the whole case following procedural problems. So we do have here a shift from justice on the merits to a more like managerial and efficiency system that Lord Wolfe recommended, and it really changed the system. I think nobody today wants to go back to the justice on the merits, but I think one of the challenges of this research is to say, okay, we have an efficiency, we have efficiency constraints, and we have questions that are related to cost division, and it is important to think about how to incentivize judges, parties to get into a settlement, but we also want to expand the horizons of judges when they have the settlement culture in the courtroom, and when they have chances to deal with aspects of the conflicts that are much deeper than the dispute as it is presented in the briefs, and to address the social conflict, and to address the hiding interest, and to address the complexity. And in that sense, the solution and the outcome is not really giving me an answer to a constructive processing of the conflict. So I feel that if there is not a theory, and not an ideology, and not a new identity for judges in this new culture of settlement, so we remain on a very narrow focus, and I feel that incentives will be always important, but incentive for what? I mean, what is the role of law? Is it finally to give decisions on the merits about justice, or has it changed? I mean, part of the kind of transgression, or I think resistance that this theory in this research suggests is that we could conceptualize a new role for law, and then incentivizing people for mediation is good. But in the mediation, they should get the real thing and the real processing that helps them promote dialogue and work on deeper interest and get results that cannot be measured by numbers, but are better in terms of educating them that society is about dialogue and more about amicable solutions. I think Wolfe kind of declared it, but it never, like, part of putting it into practice is also thinking in a fresh way about the roles of judges. So I think this is like a more utopian horizon for this discussion. Maybe let's hear people here. Omer.
Maybe, Rabeea, can you say, we hear as far as I understand this project, it's very much focused on the judge and the way the judge engages in all this issue of settlement, right? And I wonder if you can say a word about that. I mean, you said that the judges in the UK you have the procedural judge, the judge that deals with maybe the case management, and then the judge that deals with the actual trial, if I understood you correctly. And you also mentioned one rule that says that the judge should encourage the parties to participate in ADR, and maybe is even referring them to ADR. But can you say something about whether the judges themselves engage in these ADR activities? Do they help the parties actively to settle? Do they engage in this kind of mediation or managing activity, or taking actually involved in bringing the parties into a settlement? And again, is that done only in the first stage, in the procedural stage? Is it something that is also being done in the trial stage? And if you can say something about that, then.
Yes, that's interesting because we just spoke about this before the lecture. Well, my answer is, I don't have a very good answer to you, because to have a good answer, to have an accurate answer, I've got to sit in British courts and observe and really see how the litigation culture really is there. And this is something that I haven't done, so I can't really give you an informed answer. Good luck. However, my guess, and it's just a guess, probably partially informed guess, is that English judges would try to bring the parties into a settlement, whether it's in an early stage or at a later stage. That's my intuition. As far as the trial judges are concerned, I think they would do this informally. But as far as the procedural judges are concerned, I think that they are required by CPR 1.4 to try to bring the parties not only to collaborate about how to develop the process, but also to try to see whether they could settle, whether they could find a reasonable settlement. I think this is part of what they are expected to do. But again, this is just my impression, so I'm sorry not to have a more informed answer.
I would like to add that it's interesting to see that sometimes our notions about what happened in courts is different from what is really happening in courts. I think that's one of the purposes of the study. For instance, at the cost issue, I didn't talk about recent studies made by the late Ted Eisenberg and E.C. Rosenzweig and Talia Fisher, which showed that most of the assumptions that we had about the costs in Israel are not right. Meaning there is a difference between the rules to defendants and claimants. There is a difference of this, and so I think that we have to separate what we think that is happening and what we want that will be happening, that what is eventually happening.
There's a sort of a kind of a funny saying which says that in theory there should be no difference between practice and theory. In practice, there is. Just to follow up on this point, I just feel that I need to clarify the point. As I said, that I'm not sure about how trial judges, how they approach settlement. I guess that they would do just as in Israel, they would try to bring the parties to settle. But the procedural judges, let me just make this clear, are required by this rule, subsection F, to help the parties to settle the whole case, so they are required to try to prompt them to settle. And that is a formal requirement at this stage, at the case management stage. Whether that is also done in the trial stage, that's something which I don't have a clear answer for. So just to clarify this.
Okay.
So, following up what Mickey said, I think part of this research is try to understand the judicial activity of conflict resolution. And in terms of the spectrum between civil and common law, we're talking actually about a spectrum that gives an emphasis of one of the principles Miki talks about a lot in her writings about bottom-up work, meaning how does the different system, two different systems, or the spectrum of the system, sees the solutions that can come to the conflict rise from the parties. So in the pure civil system, we say the judge needs to help the parties to bring the solution, if we speak philosophically. And in the common law, we say that the parties have the ability and the responsibility to do so. And I think one thing I was missing in the discussion here is the different meaning of autonomy that the parties have in this whole discussion of cost and self-representation. There was mentioned in the sketch, but what does it mean, the autonomy on the conflict? What is the connection between the legal autonomy that the parties have on the procedure and the way it affects the conflict itself? I hope it was partially clear.
Well, I'm not sure I really followed your point on autonomy, but, well, let's say that anybody who says autonomy is, and at that point people start to disagree. So autonomy is a lot of things, and there are a lot of theories of autonomy. The minimalistic approach is to talk about free choice. So for me, the way ADR would promote autonomy is by giving litigants a free choice, a real choice, to try to talk about the conflict, try to bring up solutions that are outside the box or outside the formal realm. But still, it's a big question. How do we define the role of the judge? What is the role of the formal system? So if we want to redefine the judicial role as something which has to do with settlements and with bringing peace among the people and bringing them together and all these very nice and very important values, that has to say something about the law. How do we define law? Because what we do in court is law, is applying the law. So the formalistic approach is to say, well, right enforcement is what judges should do. They should enforce right. They should enforce the substantive law. That is, Jeremy Bentham defined the procedural system as adjunctive law. Adjunctive doesn't have any independent standing other than describing what it describes. So the procedural system, according to Bentham, has to give effect to the substantive law. If you want to change this function, then you are not just talking about the trial system or the procedural system. Now we are talking about what the function of the law is, because now we are talking about how you perceive legal right. The traditional definition of the judicial system's role is to enforce rights. That's why we go to court. Normally, we go to court. If I was hit by a car, I go and sue compensation. Right? I don't care about the insurance companies, what their approach to the accident is, whether they share my pain. I don't care about this. I mean, I want my money. At least that reflects many people's attitude. So the primary reason, according to Bentham, now I'm describing Bentham, not myself, right? What Jeremy Bentham said is that if you go to court in order to enforce legal rights, that's the only defensible justification of the procedural system. Now, we need not agree with Bentham that this is the only function, but I think it's reasonable to say that this is one of the major functions, is to apply the law. If you want to say something else, then you are saying, as I said, you are redefining what law is and what legal rights are.
The question, if we are speaking here about another perception of law and what its role in society, or whether we do need this shadow of the law and this shadow of rights perspective, but it becomes so rare and so kind of last resort that we develop methods to work in the light where it's really a terrain that is supervised by law, but is now a conflict resolution terrain. And then other reasons apply, and then notions such as relational autonomy may be more relevant, and then ideas of separating and speaking about parties as individuals are challenged. So I don't think we are moving to a kind of a very collective society in which mediation becomes the rule and there are no rules at the background. But considering the changes, the institutional changes, we're speaking about a system that needs to work in this broad new discretional area where judges find themselves and all other conflict resolution providers find themselves more inclined into developing philosophies that are kind of part of the law. Maybe we add it to the old notion, and because we need, I think, a very strict right system, and in the shadow of it, we can develop much more creative processes. Noreen.
If I can, I want to follow on that, but I want to go back to the autonomy and procedure question, because if I go to your chapter about representation, if I understand correctly, then your argument is that the system is allowed to minimize autonomy or to because the system has its own concerns, such as efficiency, and so the rights of the litigants are affected to some extent by the concerns of the system. So I would be interested in knowing what would you think, how would you apply that argument with regard to settlement? Because also in settling, litigants give up some of their procedural rights. Especially they give up the right to have a trial, and they give up the right to have a full hearing of the facts and the evidence. So when the system encourages judges to encourage parties to settle, is that problematic from the point of view?
Not at all. I think it's even compatible. I think that ADR is quite compatible with at least my perception of autonomy, because ADR provides additional options that litigants can and may choose freely. But the point is that they need to choose this freely. If they do it out of compulsion, out of pressure, cost pressure, litigation, etc., then it's not either or. And then autonomy might somewhat be diminished because they didn't really have a choice between ADR and procedure. But I just want to go back to your initial point. My proposition in that chapter is that the role of procedure is actually to facilitate autonomy, to give litigants tools by which they could present their cases and present their arguments. So procedural rules should be or could be compatible with autonomy. They don't restrict autonomy. They don't impose restrictions upon our freedom. On the contrary, the rules of procedure give us options that we could utilize in order to promote our end. So my argument is that procedural rules should give us the tools, and if they fail to do so, then they would infringe upon our autonomy.
So rules such as mandatory mediation, would that be a rule that infringes on?
Yeah, well, that's a very good. Yeah, that's a. I was trying to avoid, controversy, but I would think yes. I would think that mandatory. In a way, there's a contradiction here because if you want people to settle and to negotiate about their rights, they've got to do this freely. If you force them to do so, you either do it because you want to restrict their freedom, or you are paternalistic. You want to tell them, well, that's better for you to do this. So you've got to think of
efficiency.
Sorry?
Or you care about efficiency.
Or you care about efficiency. But then that's that's not quite true, because it depends how you define efficiency, right? Because you could say that forcing people to think about compromising the rights isn't efficient in the long run because there is a social cost for compromising rights. If I live in a society in which I know that my rights are compromised all the time, or then there's it's compromise. So I'm not sure that mandatory arbitration or mandatory ADR would be a good thing. especially if we believe in the rule of law. If the rule of again, I might be here to English, right? But
that's what you're here.
Well, I might be, but I think it's fair to say that the rule of law is a very important value, and that dictates, at least according to Joseph Raz says that access to justice, access to courts, access to right enforcement machinery is part of the rule, is a condition of the rule of law. If you don't have this, you don't have rule of law. So if we force people to turn to mediation or to arbitration, to some other alternative machinery, then we might be compromising their rights. Actually, arbitration might be an exception, because if arbitration is formal, I mean, it depends on how you, if the parties agree on a different, then that's fine. Then that's perfectly compatible with the autonomy. But the mandatory element here, it denies a choice, and then by definition, I think it's a compromise, it's an infringement upon autonomy. But within some limits, you might say that that's justifiable. Fine, that we could infringe upon autonomy in a justifiable way. Then that's fine.
Well, I think it's a great point, because in our research, it's really the core dilemma is whether you really use authority and you use actually your judicial force to sometimes even not enforce but convince and persuade and use many other mechanisms to make parties get into an agreement. Mandatory procedures such those that exist in Israel as the Mahut or the pre-mediation meeting is part of the changes in the system that, at least from the point of view of conflict resolution, assumes that conflicts need first and foremost to be resolved. There are rights, but part of the idea of the parties getting into the system, at least from my perspective, is getting the message that they have a way, in a complex way, and if you do it in a good mediation, you have a kind of a very elaborate way to transform their conflict into a more collaborative mode. And many times in the point in which they are in pursuing the claim, they don't yet see it. So I think in terms of autonomy, if it doesn't work, it doesn't work. But if you manage to help them to change the track and to do kind of a reframing and to convince them to get into a different mode, and if you do it in a way which is professional, so the system benefited, and not only benefited because they went by themselves, because findings shows us that they don't go by themselves because of the adversarial mode, but because the system gave the message that this is the preferred way to resolve conflict. I think it is important for itself. The fact that it doesn't work from various reasons, psychological and institutional, and there are ways to change the incentives, and maybe mandatory mediation should be offered in another stage, in another mode. These are subjects for discussions and to a very sophisticated framing of recommendations for changes later, but I think that institutionalizing modes of consent within the justice system, at least from my perspective, will only promote justice that is broader, justice that is more aimed also to the community and to collaboration. I'm sure you agree with me about the values.
I agree actually with everything, because I mean, my point in that chapter is merely analytical. It's just to try to analyze the relationship between autonomy and procedure. That doesn't necessarily say that we should not, in any case, intervene in people's action. I mean, I myself support mandatory representation, for example. So I would certainly, be willing to consider this. But that does not mean that there is no tension with autonomy. There might be tension. I think there is tension. There might be even some price we pay in terms of freedom. But again, we might say that's a good thing, socially valuable, because we bring people to actually achieve better results. Not necessarily, again, I'm careful to use results because we are talking about intrinsic values as well. But I mean, results in terms of looking at the dispute in a wider way. By the way, autonomy arguments are not always helpful, because if you think about class actions, one of the arguments against class actions actually was based on autonomy, right? It says, well, we kind of, if we pull people in, if we, as it were, force people to opt out, then we infringe upon their autonomy because they might be unaware of the class action. They might. We've got to put emphasis on opting in. That's what the English system does. But then evidence shows, empirical evidence shows, that people don't usually take any action. They don't opt out. They don't opt in. So actually bringing them in, forcing them in, is a good thing because then they would get their rights sort of amended, even if they didn't join the litigation. So we might pay a price in terms of autonomy, but that could be a good thing and perfectly defensible with our bill. So,
okay, so it's good to agree, and I think we are partners also. I hope that Rabeea will collaborate with other chapters and stages in the research. So thank you, Rabeea. Thank you, Hanan. Thank you, everybody.
Thank you very much.